Well, ladies and gentlemen, my name's Professor Kathy Liddell, and I am the Director of the Centre for Law, Medicine and Life Sciences at the University of Cambridge. On behalf of our centre and the Cambridge Festival, it's my pleasure to welcome you to the 2023 Baron de Lancey Lecture, which will be delivered by Professor Emily Jackson, who is a very distinguished lawyer from the London School of Economics. Her topic tonight is going to be one of the most important and controversial in medical law, assisted dying. Before we get on to tonight's main event, I would just like to take a few minutes of your time and outline the proceedings. First, I would like to mention and celebrate the origins of this lecture series. We are very grateful that the series is supported by the university's Heyden de Lancey Fund, which supports medical law research and teaching. The fund was bestowed by a foundation in Jersey that was set up in 1970 in memory of the extraordinary Baron Heyden de Lancey, who was a doctor, a lawyer, and a financier, amongst other achievements. And we are delighted that two trustees from the foundation are here with us tonight, Dr. Charlotte Ritter and Dr. Bas van Overkerk. And Dr. Ritter is actually a descendant of the Baron's family, and their daughter has studied here in Cambridge, and it's wonderful to have that ongoing connection. Following in the Baron's footsteps, the lecture series has a long history of interdisciplinary speakers, and we're going to be adding to that tonight. Professor Jackson's research and teaching interests focus on the intersection of law, healthcare, and bioethics. She has published extensively on a broad range of topics such as reproductive rights, medical negligence, the regulation of the pharmaceutical industry. And she has also written a wonderful and scholarly textbook, which I can confirm is used by students at Cambridge, many of whom actually I've seen in the audience tonight. For her own part, Professor Jackson studied at Oxford. Everyone has a flaw, but she did rectify this quickly, becoming a lecturer and fellow at St. Catherine's College in Cambridge. She was appointed to her first chair in 2004 at Queen Mary University in London, and shortly afterwards to a chair at LSE in 2007. She became the head of the LSE department in 2012, and throughout her career has been a member of numerous high-level committees, including the British Medical Association, the Human Fertilisation Embryology Authority, and the Judicial Appointments Commission. So in short, she has had and made a major contribution to the laws and the courts that govern medical aspects of our lives. Hence, as I think you will agree, she is an outstanding choice to give our lecture tonight. There are not many certainties in our world, but one is that we will all die. And we must address the issues around it, despite the controversies, and we need to do so in a way that is intellectual and compassionate, which I'm sure Emily will help us do tonight. Just before I hand over to you, Emily, I'm just going to run through a couple of logistics. The lecture is being simultaneously web streamed for those who cannot join us in person. After the presentation, we will have a live Q&A session, which will run until about 6:40 p.m. For those of you watching online, the chat function has been disabled, but you can pose your questions in the Q&A box at the bottom of the screen. They will be collected by the organisers for the live Q&A at the end, and we will also take, of course, raised hands from the in-person audience. And with that, I would like now to invite you all to, in the customary way, welcome Professor Emily Jackson to the lecture.
Can I get rid of this? So I'm not looking at myself. Thank you.
Yeah, I'm running this.
Okay. Thank you very much, Kathy, for that very generous introduction. Thank you very much also to the Baron de Lancey Fund. I'm very grateful for the invitation to be here. I'm grateful to Kathy, Matt, Jeff and Georgia for organising this, and I'm very grateful to you all for being here. It's lovely to see so many people. So I think this is a really interesting moment to think about the legalisation of assisted dying. The Health and Social Care Committee, as many of you will know, is taking evidence as part of its inquiry into the subject. The Nuffield Council on Bioethics is about to start work on its citizens' jury work on assisted dying. So there's a lot going on. So I think what I wanted to do today is take a bit of time to talk about some of the really difficult questions that arise when you're thinking about legalisation. Not suggesting that I have all the answers by any means. I think there are some genuinely really tough questions here. And I wanted to talk about how there's sometimes a tendency in relation to assisted dying to solve one problem, but create another. And also another issue, I think one encounters quite a lot, is the sense that people are sometimes talking past each other. That opponents and supporters of legalisation are sometimes just talking about different groups of patients when they're talking to each other. So I just wanted to explore some of those issues. But just by way of introduction, supporters of legalisation in the UK have essentially pursued a twin-track strategy in terms of trying to change the law. So there have been a series of judicial review actions in the courts. And of course, those are brought by individuals about their individual circumstances, but those individuals are very often supported by campaigning organisations. So there's an intention to try to change the law as well as resolve an individual's case. So there's judicial review actions in court, and at the same time there's parliamentary reform as a different strategy. So it's the Suicide Act which is the target of most of these legal challenges in the courts. And it's a very strange piece of legislation, as some of you will be aware. So for compassionate reasons, it decriminalised suicide in 1961, but retained assisted suicide as a criminal offence. That's odd to begin with, because it's very odd for assisting somebody to do something lawful to itself be criminal. There are a whole series of offences of assisting, but they're usually assisting someone to do something that is itself criminal. So that's strange to begin with. Another thing that I think strikes a lot of people as strange is that it treats encouraging suicide and assisting suicide in the same way, that they're conflated in the statute. And I think for many people, they're rather different things. It's a serious crime. You can go to prison for up to 14 years. Another oddity on the face of the Act is that even in 1961, it was recognised that it wouldn't always be in the public interest to prosecute in cases of assisting a suicide. So the statute states very explicitly no prosecution can go ahead without the specific consent of the Director of Public Prosecutions. And since Debbie Purdy's case, there's been a specific Crown Prosecution Service policy setting out a series of factors in favour of prosecution and a series of factors against. And most of the judicial review actions, they differ in all sorts of respects, but broadly speaking, the target of these judicial review actions has been to the fact that Suicide Act has a blanket ban on assisted suicide. It applies to everybody. It doesn't create any exceptions for people who are not vulnerable. So it's for everybody. It doesn't matter if you're completely competent, completely know what this is what you want, there's a blanket ban for everybody. And it's the blanket nature of the ban that has been what has been challenged in the courts unsuccessfully so far. And so in those courts challenges, in those challenges, judicial review actions, obviously they raise a range of issues, but it's very common to hear judges say things like, this is a question that is better dealt with by Parliament, that Parliament is the place, if you're going to decide to do something as significant as change the law here, it should be for Parliament. And one of the reasons for that is that in an individual judicial review action, the only thing that is at issue is an individual circumstance, whereas Parliament can take into account a wider range of issues, including, of course, the interests of people who are not represented in that case. So there's been a series of judicial review actions. There have also been attempts to change the law in Parliament, again, so far unsuccessfully, through versions of this draft bill. And I think the first really interesting thing to note about the draft assisted by dying bill is that it would exclude many of the people who have brought judicial review actions in the courts. So that's already a slight oddity that we have a statute, a potential statute, that actually wouldn't solve the issue for a lot of the people who have brought judicial review actions. So I think what one can gather from that is that even if this bill were to be passed, even if it were to become law, litigation would continue because it wouldn't give a right to an assisted death to everybody and would specifically exclude people who have brought actions in the past. So the bill wouldn't solve the litigation issue. I'm just going to pull out a couple of things that I think are interesting in terms of the criteria on the face of the bill. First of all is the reference to terminal illness. That's the only bit of the bill which refers to the condition of the person seeking an assisted death. And that's quite strange in some ways, because I think for most people who think that assisted dying should be an option, it isn't terminal illness, which is the reason. It's unbearable suffering that can't be relieved in any other way. And obviously, terminal illness is not necessarily the same thing as unbearable suffering that can't be relieved in any other way. So you could have somebody who is suffering unbearably and their suffering can't be relieved, but who doesn't fit within the terminal illness definition, which is less than 6 months, expected to die within the next 6 months. But you could also have somebody who is terminally ill, but isn't suffering irremediably and unbearably. So terminal illness doesn't really quite fit there. And of course, as we all know, predictions of life expectancy are notoriously unreliable. So in terms of having that as a statutory criterion, it's a bit vague and imprecise. One of the other criteria towards the bottom of the slide is that you have to have capacity to make the decision. And of course, at first you might think, well, of course, that's perfectly sensible. It's a really sensible thing that somebody should need to have capacity. But of course, this could raise a potential unintended consequence of people who have degenerative conditions, who are frightened that they might lose capacity, actually ending up seeking an assisted death sooner than they would ideally like to, for fear that they will lose eligibility. So if people feel that there's a point at which they're not going to be able to access this anymore, you've then perhaps got the problem of people thinking, going to have to do this while I still can, because at some point I won't be able to. There's also at the top of the slide a criterion that you need the consent of the High Court to do this. I think what's completely clear is that the High Court doesn't have the capacity to do this routinely. So people have extrapolated from the data from Oregon about how, if it were to be legalized here, about how many assisted deaths would there be each year. And roughly 5,000, 5,800 is the sorts of numbers you get there. The High Court just simply doesn't have enough slack to make 5,800 more decisions a year. The High Court is already under extreme pressure. So there's a capacity issue there. I think you could also say that if somebody is in the final days of their life, having to make an application to the court could be said to be quite cruel and not the best use of those final days when they want to be with the people they love. Much better, I think, if one was going to retain the High Court as a criterion here, is to save that for difficult cases and to make sure the High Court is available to decide cases where maybe there's some disagreement or the case is difficult for another reason. So I wanted to now talk about some things that I think we can learn, but also worry about, perhaps from countries that have legalized assisted dying. I'm going to go through some various issues in relation to this. So What can we learn from these countries? Well, I think the first thing we can learn is that there are now rather a lot of them. So if we've been having this conversation, as I hope it will turn out to be 20 years ago, would have been very few. Now there's rather a lot. And I think for me, one of the most compelling pieces of evidence that I've seen from countries where it's legal is that the availability of assisted dying benefits many more people than the small number of people who might actually use it, because it provides people with some sort of reassurance that they could stop everything if it became unbearable, that it's that almost, as the quote at the bottom of the slide, almost an insurance policy against future suffering, a way out if things became too difficult. And I think that is reassuring for a lot of people. There's some really interesting psychological evidence of those sorts of experiments where they inflict pain on people under a controlled setting. And when you do that to people who have an off switch, people can withstand a whole lot more pain than people who don't have an off switch. If you know that you can stop it, your capacity to deal with things is a lot greater. And I think one of the most powerful illustrations of this for me is two interviews that a dear friend of two friends of mine gave to The Guardian a few years ago. So this is an amazing woman, really joyful spirit called Jo Beecham, who felt very passionately about what she did. And what she did was buy poison from the internet and kept it in her fridge. And the first, she had cancer and she knew she was going to die. So she gave these two interviews a few months apart to The Guardian. And in the first one, when it was about her poison in the fridge and why she'd bought it and how freaked out her friends were by the life-ending medicine behind the bags of lettuce. But it was about her feeling really strongly that she should have this. And then the second interview, I think, is incredibly moving, just before she died, where she said she wasn't going to use it. It was still in the fridge, but she decided that she didn't need to use it. She'd had some excellent care, but she didn't regret having it there. She said she was really clear it had helped her immeasurably to know it was there. It was a kind of resource that she had that she in the end didn't use, but was really helpful in enabling her to bear what her disease had brought her. Okay, so another question that I think is really interesting about that we can think about in relation to evidence from countries where assisted dying has been legalized is the question about the involvement of doctors. So in most countries where it's lawful, the involvement of healthcare professionals is both mandatory and optional, which might sound a bit counterintuitive. So it's mandatory in the sense that doctors have to confirm medicalized eligibility criteria. They have to prescribe the medicines, and where it's euthanasia that's lawful, they have to also administer the medicines. At the same time, doctors have a right conscientiously to object to participation. So that means that access to assisted dying depends upon there being enough doctors who don't conscientiously object to do the things that only doctors can do. So it's a kind of reliance on, do we have enough doctors who are going to actually be willing to do this? There are, of course, some very good reasons to involve doctors in assisted dying. They have the necessary knowledge and skill to diagnose and confirm eligibility criteria, which are medicalized, things like capacity, things like terminal illness, etc. They have the skill to end a life effectively and painlessly. They can do this more effectively, I think, than patients can themselves. There's some evidence from Belgium that you could integrate assisted dying and palliative care to ensure continuity of care. But I think the involvement of doctors maybe also serves a broader purpose of legitimation, that the idea that this decision has been sanctioned by a doctor and is taking place in a medicalized setting perhaps makes it easier for people to feel okay that this is an okay thing to do, and perhaps makes it easier for relatives and loved ones that this is a medicalized process. It's not something shady and dodgy. So there's, I think, a range of reasons to involve doctors. At the same time, I think there are some good reasons not to involve doctors. One might be that where people are against assisted dying because they worry about its impact on the medical profession, or they worry about its impact on patient trust, that those arguments kind of go away in some sense if you're not requiring doctors to be involved. I think there's also some evidence that involvement in assisted dying isn't always easy for doctors. I think there's obviously a range of evidence here, and there are some doctors who describe how incredibly moving and satisfying it is to be involved in the provision of assisted dying, to be with somebody at such a critical, pivotal moment for them, and to help them make a decision which matters to them. I think can be incredibly satisfying, but at the same time, I think it can be problematic. And I think there is certainly evidence that legalization support for legalization is in general, on average, lower amongst doctors than it is amongst the general public. And I think there's some evidence that doctors find involvement in assisted dying particularly difficult in cases where the patient's suffering is psychosocial or mental. So where you've got what you might think of as a more standard case where somebody is in the end stage of dying from cancer, that I think those cases are perhaps a bit more straightforward for doctors than a case where the person's suffering is to do with how they feel about life or is as a result of a mental disorder. And advanced decisions, I think, are very, very difficult for doctors and in practice rare. So in the Netherlands and Belgium, in theory, assisted dying is available in cases of psychiatric suffering. In practice, it's very rare. Similarly, in theory, advanced decisions for euthanasia are possible, but in practice, incredibly rare. So there's some evidence that there's increasing patient demand for those types of assisted dying with which doctors are least comfortable, the cases where the patient suffering is mental or psychosocial or advanced decisions. So I think nevertheless, doctors clearly play a pivotal role in relation to legalization. And the move amongst doctors' organizations from an official position of opposition to a position of neutrality is a really significant one. When that happened in Victoria in Australia, it was a significant move. And it's happened in the UK. So, but in a slightly complicated way, if you look at the statistics here. So the Royal College of Physicians and British Medical Association are now officially neutral rather than opposed. In contrast, Royal College of General Practitioners and the Association for Palliative Medicine continue to oppose a change in the law. And I've put these statistics up just because it's quite interesting to see what you do with statistics like this, because in both the Royal College of Physicians survey and the GP survey, the largest percentage, the largest single percentage was for opposition. So the group that is the largest one of these three is for continued opposition. But if you add up those in favour of a change in the law and in favour of neutrality, that's actually bigger. So it's interesting that that was the case for both the Royal College of Physicians and the Royal College of General Practitioners. And one decided that that meant they needed to move towards neutrality, whereas the other decided that that meant they had to continue to be opposed. So there's there's whether or not it's the single number or the added up number that counts. But I think this is important and significant, because I think doctors in any legalization process, doctors are going to play a critical role. But I think that raises some really interesting questions for the future about whether or not robotics might have any impact here. Would there be advantages to using robots to replace doctors' role in the administration of assisted dying? Could that be something that takes doctors out of the picture? And at the same time, could robots provide more therapeutic and care services that could help people who are seeking assisted dying. So there's, I think, some big questions for the future there. And one question that I certainly don't have an answer to is whether or not determining eligibility for assisted dying is something that always would have to be done by a person. Could you ever move towards a situation in which we were comfortable with an algorithm that could make these judgments? Or do we think this is actually so big, so important, a person has to make these decisions? As I say, I don't have an answer to any of that. But these are genuinely difficult questions. I wanted to now turn towards considering the question of vulnerability, because the most commonly cited reason in the UK for either opposition to a change in the law or for caution is the needs of the vulnerable. So just as an example, House of Lords Select Committee from almost 20 years ago now, concerned about the vulnerable. Lady Hale in the Nicholson case, the only legitimate aim for this interference with people's rights to respect for their private and family life was the protection of the vulnerable. And the last time the assisted dying bill was debated in the House of Commons, it was coercion of the vulnerable that was the most difficult issue. So the general legal position in the UK is we need a blanket ban on assisted dying to protect the vulnerable. That's the that seems to be the position here. So what can we learn from the countries that have legalized it? Well, in particular from Europe and the US, where it's been lawful for longest. One thing that I think is interesting is that people accessing assisted dying in these jurisdictions tend to have something in common other than vulnerability. So they're more frequently irreligious, well-educated, middle class, they more commonly live alone, and they more commonly live in urban neighborhoods. In short, it's relatively privileged people who make most use of assisted dying. And that's led some people to suggest that actually it's privileged people who are vulnerable here. So this quote, I think, is a good one. We need to be really worried about rich, educated white men. They're the new vulnerable here. Those are the people we need to be concerned about, which is a really interesting turning on its head of vulnerability. But what's going on here? Well, I think what's going on here is that people who express an interest in assisted dying, the general theme that comes out from this evidence is that people who are used to having high levels of control over their lives, and that interest in assisted dying is an attempt to exert and exercise some control over a process that often doesn't leave much opportunity for control. And going back to the friend of friends of mine with her poison in the fridge, that was definitely an attempt to exert some control over what was happening to her. So I think this is really interesting, this growing body of evidence, that it's the patient's beliefs, the patient's characteristics and priorities, rather than their illness or symptoms, which are the major predictor of a desire for assisted dying. So it's not that the patient has a particular disease, it's that there's somebody who really, really has been used to exercising control and wants to retain some sort of control. So if the reason why people are interested in assisted dying is because of their beliefs and their values, I think there are limits to what palliative care can do about those beliefs and values. It's not clear that they can be relieved by palliative care. If it's your desire for control, then it's not clear that palliative care can do very much about your need for control. It can obviously make you more comfortable. It can give you as much control as it can. But if it's your desire to exert more control, then it's not clear that that can be, it's not a symptom that you can treat in the same way as you can treat pain, for example. I think there's also an interesting question here, which is that if we're focused when we're thinking about legalization on protecting the vulnerable, one of the risks then is that perhaps we don't take into enough account the needs and interests of patients who are not vulnerable, for whom, for example, control is perhaps especially important. So if you were concerned I mean, obviously we need to be concerned about the vulnerable, but if we were also thinking about the not vulnerable as people who have interests here, then things like advanced decisions might be especially important because of that need to exert control. There's also something of a paradox here in some ways, because the need for control that people are exerting in assisted dying involves ceding quite a lot of control to doctors whose ultimate decision this is. So you exert control by, in a sense, putting your fate in the hands of a doctor who has the control over whether you can do this. One really interesting and difficult question, I think genuinely a really, really difficult question that arises in a system of legalized assisted dying, is whether or not doctors could ever proactively raise it as an option with patients. So just as an example, in Victoria in Australia, this is prohibited. You mustn't influence a patient by raising this as an option, because obviously you might plant the idea in the minds of the patient. They might think you're recommending it. So doctors mustn't raise this with patients. In many ways, this seems entirely sensible. We don't want people being persuaded or feeling that they ought to do this. And also, you might also think that a patient who does meet the eligibility criteria might prefer not to know that. They might prefer that a doctor doesn't tell them that they're now in that territory where they satisfy these criteria. So in many ways, this seems entirely sensible that doctors mustn't proactively raise it. But that causes this other problem, again, a kind of unintended consequence here, which is if doctors can't raise this, access might be only available to people who know about it. That you're going to exclude disadvantaged people who don't know about this as an option, because it's only the people who are already clued up and already know this is an option for them who are going to be able to take advantage of this. So I think this raises a really interesting question, again, to which I really don't have the answer, which is the evidence that underprivileged people make much less use of assisted dying, could that actually be pointing to some sort of access gap because they don't know to ask for it? So there are really interesting, again, and difficult questions here. I don't think there's any easy solution. I mean, I think one thing that one could say is that if there is going to be information available so that people aren't excluded because they don't have the resources to know about this already themselves, they don't have the privilege to know about it already themselves, that any information that's provided would have to be provided in a really neutral and careful way as possible. Another really, really difficult question, I think, is the question of people with mental disabilities and whether or not they should be excluded from any legalized assisted dying law. You might want to say that to be on the safe side, we should exclude people with mental disabilities, but that would be to deny a group access to a service because of their disability, and that is really, really problematic. So I think there's a history, obviously a really awful history of treating disabled people as if they're all incompetent, easily coerced. And I think to just exclude people automatically on those grounds might contribute to stigmatization, marginalization, the removal of agency for a whole group of people. Does that mean then that we need to give people who have mental disabilities the same choices as everybody else? In some ways, if we're treating people equally, we should do that. But then, of course, that raises a really difficult question, I think, which is how does assisted suicide interact with the public health goal of suicide prevention, which is obviously incredibly important. And I think one could clearly draw a line, I think, between what the distorted thinking that happens to many people who commit suicide, where they believe for whatever reasons that their loved ones might be better off if they weren't there. That's very different to a scenario in which somebody rationally, logically thinks that their suffering can't be relieved in any other way. But I think while, if I describe it like that, they sound different, in practice, these are fine lines and these cases can be really difficult. So this is genuinely, again, hard and there isn't any easy answer. But I think that it's clear that if we are going to exclude people on the basis of vulnerability, then in line with what was said in the Dutchman case in Canada, that we shouldn't be excluding people en masse because they belong to a group. That if we're going to exclude people, it has to be, and judge their vulnerability, it has to be on a case-by-case basis rather than lumping everybody together and treating them as though they're incapable as a result of having a particular condition. So we have to look at their capacity as a case-by-case thing rather than lumping people together. Another really, really difficult issue is cases where someone's suffering might in part be because their social care or their circumstances are inadequate. So what do we do if it's the inadequacy of support services that make a person's suffering intolerable? How do we handle that? Well, obviously, the right answer there is to make sure that they have all the support services that they need and to make sure that those are in place. But I think we would be closing our eyes to reality if we thought that that was necessarily always going to happen. But I think that raises a question that, again, I'm genuinely really struggling with myself, is does the inadequacy of care services mean that we should prohibit all access to assisted dying until care and support services are perfect? If we did do that, then clearly in the UK at the moment, that would be an absolute bar for certainly for the foreseeable future, because we know how inadequate and overstretched social care services are. So I think there's a real worry of saying, well, we can't go anywhere near this because government hasn't funded social care properly. That feels like a really kind of unkind thing to say, that when they can say you can't have access to this because government funding of social care is inadequate. At the same time, one of the things that I think is worrying is that, can we really be confident, given what we know about social care services being on their knees in the UK, that somebody who makes a request for an assisted death in the UK, if it was legal, would they first receive a comprehensive package of support services to improve their quality of life? I think any of us who have had experience of people trying to navigate the social care system in the UK recently would say that it would be very hard to be confident that that would happen. So I really think these are tough questions, but I think it's important to face them. But on vulnerability, there's, I think, a slight paradox in the way we sometimes approach vulnerability and assisted dying, which is to say that our attitude to assisted dying for vulnerable people is completely different from how we think about other choices that patients might make which will have the same outcome, i.e. the patient's death. So where you've got a patient refusing life-sustaining treatment, we think, the legal system in the UK thinks that it can tell the difference between people who have capacity and who don't have capacity, who are making voluntary choices and who are not making voluntary choices. So if we think we can do that distinguishing, we can tell that somebody is vulnerable and perhaps not making a decision for themselves in one case, why can't we do it in another? That seems to me to be quite illogical, to say that our judges or whoever it might be are perfectly capable of drawing these lines when a patient wants to make one decision which will end their life, but we can't do that if they want to make a different one. And it seems to me to be hard to justify. And I think a very compelling legal case from more than 20 years ago now in the UK was the Ms. B case, a really powerful case that was decided by the then president of the family division. The Ms. B case involved a woman, Ms. B, who was competent and needed artificial ventilation. So she was connected to an artificial ventilator. And you know how we're all used to, when you're watching the 10 o'clock news, seeing court drawings, because you can't have photographs in a court. So there's the sketch and the court artist. Well, Dame Elizabeth Butler-Sloss went to the bedside of Ms. B. So the court drawing here is of the judge sitting by Ms. B's bed. Now, I still remember that image as being incredibly powerful. Dame Elizabeth Butler-Sloss found that Ms. B was competent and not being coerced, able to make this decision. And I think she explains really powerfully that there's a real danger of a kind of benevolent paternalism, which doesn't recognise the autonomy of somebody who is disabled. Ms. B hadn't spent time in a spinal rehabilitation unit, but that didn't affect the fact that she was capable of making this decision. Having decided that Ms. B was competent, that meant that her continued treatment by the trust was unlawful. It was actually an assault, because to give somebody invasive treatment when they are refusing it against their wishes is unlawful. So Ms. B wasn't just able to ask to have her ventilator withdrawn, she could insist on it. She had a right to have it withdrawn because it was unlawful to continue to ventilate her against her wishes. Now, obviously, there are differences between refusing life-prolonging treatment and assisted dying. You get into the really thorny, massively complicated acts and omissions distinction. We can go there if you like in the questions. But I think the key thing for me in this case is that Ms. B was competent to make this decision, and the judge felt capable of saying that she was. And would that be impossible if the decision Ms. B wanted to make was a different one involving assisted dying? I wanted to say something briefly about slippery slope arguments, because I think they're interesting in all sorts of ways, because they're very, very common here, and they often fall back on this issue of vulnerability. So what is going on, I think, in a slippery slope argument is that people who believe that assisted dying is always wrong don't make that argument generally, because that argument is unlikely to be persuasive, given that we know that 80 to 90% of the public are in favour of allowing assisted dying. So to mount an argument against assisted dying to say it's wrong for everybody is unlikely to persuade the public. So the slippery slope argument is an alternative. So you're not saying it's always morally wrong. You're saying something slightly different. You're saying we can't allow somebody who is not vulnerable to have access to this, because if we do, we're not so worried about them, but if we allow them to have access to it, there's a real danger that we'll slide down the slope and someone who is vulnerable, someone else, will be pressurized into opting for assisted dying. So I think what's going on often in a slippery slope argument is a way of deflecting attention from the person who's clearly competent, clearly making a voluntary choice, and instead of saying to them, you can't have access to this because I think it would be wrong for you to access it, the slippery slope argument is you can't have access to it because if you do, we might be confident about your capacity, but we're not confident that we could confine it to you, and we'll end up giving it to somebody who is vulnerable. So I think that's quite a problematic argument, because I think it's quite problematic to say to somebody who is clearly not vulnerable, we don't think that you can have what you want. We're not going to give you what you want. And I'm not going to argue that you shouldn't have it because nobody should have it. I'm going to say you shouldn't have it because of someone else. So I think you could say, in making that sort of argument, we're treating these non-vulnerable people almost as a means to an end of saying that nobody can have it, rather than what would I think be a more sensible and is normally a response to slippery slope arguments in other contexts, is to say, well, we should regulate, we should confine it to the group of people that we think are not vulnerable, and we should find a way, as we do in relation to withdrawal of treatment case, withdrawal of life-prolonging treatment, a way to say we can tell the difference between vulnerable and not vulnerable people. So we do that in relation to withdrawal of life-prolonging treatment. So I think generally regulation is a better response to a slippery slope, because it takes seriously the interests of the people at the top of the slope, rather than saying we've just got to be concerned with the bottom. I'm not saying that concern for the vulnerable isn't important. As I hope I've illustrated, I genuinely find these questions seriously, seriously hard. And I don't think this is easy at all. I think you could also talk about slippery slope arguments as kind of an example of strategic, almost secularization, that people have really, really strongly felt and faith-based objections to assisted dying, which obviously deserve the utmost respect in relation to how they organize their own lives. But people are generally not making those arguments in the public forum here, and are much more commonly saying, not that this is immoral for everybody, but that it wouldn't work well enough in practice, that it would be difficult to protect the vulnerable. So I think you could draw a parallel with some of the arguments that are made in relation to abortion, which is to try to widen the appeal of people whose genuine belief is that it's always wrong. You instead say, well, it's bad for women, in order to appeal to a broader constituency of people. So I'm not in any way suggesting that slippery slope arguments are always strategic in that way. But I think what worries me about slippery slope arguments is that we just forget about the person at the top of the slope as though their interests don't matter. And I think they do. So there are a number of sources of pressure, I think, on the status quo in the UK. One is that obviously UK citizens can travel to Dignitas in Switzerland to avail themselves of assisted dying if they want to. And I think you could say already that that is a bit unevenly available, because you need money to do that, but you also need the social resources, somebody to help you navigate that. It's not something that everybody can access. So it's available to people, but not by any means to everybody. And people who do use the services of Dignitas in Switzerland obviously have to die overseas and can't do what most people would want, which is to die at home. I think really compellingly, lots of people who UK citizens who've died in Dignitas clinics have had to make the journey while they were still fit enough to do so. And that means that many of them died earlier, sooner than they would have liked to, sooner than they would have done if it had been available in the UK. It's also overwhelmingly likely that people who've died in Dignitas clinics in Switzerland would have in the end had natural deaths in the UK, because they wouldn't have felt the need that people felt, I've got to avail myself of this option while I can still travel. As time goes on, there's an increasing volume of cases of people who have helped somebody in some way to get to Dignitas, booking a train ticket, traveling with them, but who are not prosecuted. There's the interesting question of what happens if Switzerland closes what's sometimes been described as a safety valve, if it confines it to residents. Would people say that they had a legitimate expectation of this as an option? Something I think is really interesting in relation to this as an expectation is it was really interesting when the restrictions on leaving your home, restrictions on travel, first came in response to the pandemic, that one of the first things that was announced was that traveling to Dignitas was a legitimate excuse to leave your house. So people still could, in the pandemic, go to Dignitas. So the government was acknowledging there that people had an expectation that they could do this and they were allowed to travel. I think you could say, as I suggested earlier, that the UK is increasingly a little bit of an outlier here, as more and more countries legalise it. I think it becomes harder to mount the argument that the UK uniquely can't and shouldn't go anywhere near it. Of course, the UK might decide it doesn't want to, but I think the idea that we uniquely wouldn't be able to devise legislation, I think, is harder to justify. And I think, of course, there are demographic changes, that as the baby boomer generation, which has definitely been used to exercising control over its life, as it becomes, as members of the baby boomer generation become very elderly, I think they have a group of people who are less tolerant of the lack of control that people sometimes have at the end of their life. So, as I said, it's an interesting time. The House of Commons Health and Social Care Committee is currently hearing evidence in relation to its inquiry into assisted dying. And the final thing I just wanted to say something about was the importance of talking about death and dying at the end of life. So, sorry, I'll find my page. This might seem like a slightly weird point to end on, but I think there's quite a lot of evidence that the desire to talk about hastening death is actually really quite common. It doesn't necessarily mean that people want to access an assisted death. It can exist for a whole range of reasons. People can want reassurance. It could be a way of trying to say that you've accepted that you're dying. It can be a coping strategy. But the desire to talk about hastening death is something that I think is quite common amongst people towards the end of their life. And one of the problems about having a system in which assisted dying is absolutely unlawful is that a response to that sort of somebody saying they want to talk about a desire to hasten death, response can often be, well, we just can't help you with that. We can't talk to you about that because we would be potentially doing something criminal. And I think anything that shuts down those conversations is a problem. Of course, in a system of legalized assisted dying, there could be problems too, because you might funnel those sorts of conversations into the eligibility criteria. Do you fit them? Whereas I think actually a key and core goal of any way in which you approach assisted dying or anything to do with death is that we should promote, as far as we can, openness about death, talking openly about death, because I think there's overwhelming evidence that that's a good thing. I was involved decades ago in the review of the Liverpool Care Pathway, which, as some of you may know, some of you may not, but it was a really well-intentioned effort to bring the principles of hospice care into the hospital setting, so that people who maybe were dying on a general medical ward could benefit from the knowledge of palliative care that the hospice movement had developed. So it was an attempt to try to say, let's make sure that busy nurses in a general medical ward know what the best thing to do is at the end of life, know what care people should have. The problem was that there was a concerted campaign by the Daily Telegraph and the Daily Mail to say that the Liverpool Care Pathway was an example of patients being euthanized by doctors, that people were being put on this pathway to free up beds and to be have their lives brought to an end. And what was really interesting about the investigations that we did as part of this panel is it became evident that what had happened, we went to lots of meetings with families who were extremely angry and were convinced that their loved ones had been killed by being put on the pathway. But what became apparent was that that wasn't what had happened. That what had happened is that the loved ones, the relatives, hadn't understood that the person that they loved was dying. They thought they were fine, and then they put on the pathway and they died. And so of course they thought it was the pathway that was to blame. And so what became apparent from this is that the problem wasn't the pathway. The problem was that there wasn't good enough communication about death. There wasn't good enough communication with loved ones about what was going to happen, what death would be like, and the fact that somebody was actually dying. So the problem was that the loved ones hadn't appreciated that the person was actually dying. And so it was clear that there was poor communication, but it was also clear that there wasn't enough training for doctors in medical school for talking to people about death and dying, that it was sometimes talking to relatives about death was an afternoon course that it was easy to miss. So I think the core priority, whatever we do about legalization of assisted dying, has to be to say that dying and talking openly about dying should be seen as core NHS business. And I'll leave it there.